I never imagined that running a legitimate heating and cooling business from my home office would turn into a legal nightmare that would consume 2 years of my life. But that's exactly what happened when Patricia Thornton took over as president of the Meadowbrook Estates Homeowners Association in Gilbert, Arizona. It started on a Tuesday morning in March when I was sitting at my kitchen table, going through invoices for my company, Stellar Climate Solutions. I had been running the business for 5 years, and everything was going smoothly. My name is Quincy Stevenson, and I had built my heating and air conditioning business from the ground up after getting my contractor's license. The beauty of my operation was that it was low impact. I worked from home, handled scheduling and billing from my office, and met clients at their properties for installations and repairs. My commercial vans were parked in my driveway, neatly maintained and professional looking with my company logo on the sides. That morning, I received a certified letter from the HOA. The envelope had that official, intimidating quality that immediately set my nerves on edge. I opened it and read the contents 3 times before the words actually registered. The letter stated that effective immediately, I was in violation of Meadowbrook Estates covenants, conditions, and restrictions. According to Patricia Thornton, my business operations were prohibited under Article 7, Section 3, which supposedly banned commercial enterprises from operating within the community. I grabbed my copy of the HOA bylaws and read through the relevant section. It mentioned that residents could not operate businesses that created excessive noise, traffic, or disturbances to other residents. There was nothing about a blanket ban on home-based businesses. I had always been careful. My client meetings happened at their locations, not mine. The only traffic to my house was normal residential activity. I didn't have customers coming and going, no inventory stored outside, nothing that would qualify as a disturbance. I decided to attend the next HOA meeting, scheduled for that Thursday evening at the community center. When I arrived, about 30 residents were scattered around the room, sitting in folding chairs and chatting among themselves. Patricia stood at the front, a woman in her late 40s with severely cut blonde hair and an expression that suggested she had just bitten into something sour. She was shuffling papers and whispering to 2 other board members, Linda Morrison and Carol Henderson, both of whom seemed to hang on her every word. The meeting began with standard business, discussions about landscaping contracts and pool maintenance. Then Patricia cleared her throat and announced that they would be addressing violations. My stomach tightened. "We have a serious matter to discuss regarding Mr. Stevenson at 4782 Sage Brush Lane," Patricia said, her voice carrying that particular tone of manufactured concern that I would come to know too well. "It has come to our attention that he is running a commercial HVAC business from his residence in direct violation of our community standards." I raised my hand. "I would like to address that." Patricia's lips pressed into a thin line. "The board has already made its determination." "Then the board made its determination without speaking to me first," I said, standing up. "I have operated Stellar Climate Solutions from my home office for 5 years. I schedule appointments, handle billing, and do administrative work from home. All actual service calls happen at client locations. There is no commercial activity happening here that affects anyone in this neighborhood." "You have commercial vehicles parked in your driveway," Linda Morrison interjected, reading from a notepad. "2 large vans with commercial signage, which are parked neatly in my driveway, not on the street, not blocking anyone's view or access," I countered. "And there's nothing in the bylaws that prohibits commercial vehicles." Patricia held up a hand as if she were stopping traffic. "Mr. Stevenson, The board has reviewed the covenants thoroughly. The intent of our restrictions is to maintain the residential character of our community. Your business operations, regardless of where the actual work is performed, constitute a commercial enterprise based in this neighborhood. That is not acceptable. Show me where in the bylaws it says that, I challenged. She pulled out a document and read from it. Article 7, Section 3 states that no property shall be used for commercial purposes that alter the residential nature of the community. My business doesn't alter anything, I said. I'm not running a retail store. I'm not having clients come to my house. I'm doing paperwork. The commercial vehicles are enough, Carol Henderson added. They're an eyesore, an eyesore. My well-maintained, professional-looking vans that were barely 3 years old were being called an eyesore. I looked around the room at other residents. Some looked sympathetic, others disinterested. A few nodded in agreement with Patricia's assessment. I would like to formally dispute this ruling, I said. This seems like an overly broad interpretation of the bylaws that could affect anyone who does any kind of work from home. Your dispute is noted, Patricia said with a dismissive wave. However, the board's decision stands. You have 30 days to cease all business operations from your property or face fines of $200 per day. I left that meeting furious and confused. $200 per day would destroy me financially within weeks. This was my livelihood, my business that I had spent years building. I went home and immediately started researching attorneys who specialized in HOA disputes. That's how I found myself in the office of Margaret Chen 2 days later. She was a sharp attorney in her 50s who had handled numerous HOA cases throughout Arizona. Her office in downtown Scottsdale was decorated with framed verdicts and settlements, a testament to her success rate. The problem with HOAs, Margaret explained after I laid out my situation, is that they often overreach their authority. They interpret their governing documents in the broadest possible way to give themselves maximum control. But Arizona law actually provides significant protections for homeowners, especially regarding home-based businesses. So they can't do this, I asked. Well, they can try and they are trying, she said with a slight smile. But Arizona Revised Statutes, Section 33, 1808, specifically protects the right of homeowners to operate home-based businesses as long as those businesses don't violate specific reasonable restrictions. The key word is reasonable. She pulled up the statute on her computer and showed me the relevant sections. The law stated that HOAs could not prohibit home-based businesses unless they created a demonstrable nuisance, increased traffic beyond normal residential levels, or required modifications to the property that violated architectural standards. Your business doesn't do any of those things, Margaret said. You work from a home office. You meet clients at their locations. The only physical evidence of your business is the vehicles in your driveway, and there's nothing inherently problematic about that. So what do we do? I asked. First, I'll send them a letter explaining that their interpretation violates state law and demanding they rescind the violation notice. If they refuse, which based on what you have told me about this Patricia person, they probably will, then we file suit. How much is this going to cost me? Margaret was honest. It won't be cheap. We're looking at potentially $20,000 to $30,000 if it goes all the way through court. But if we win, and I believe we will, the court can order them to pay your attorney fees. I left her office with a mixture of hope and dread. The thought of spending that much money on legal fees was terrifying, but the alternative was shutting down my business, which would cost me far more in the long run. Margaret sent her letter to the HOA board the following week. It was thorough and professional, citing specific Arizona statutes and case law. She explained that my business operations were protected under state law and that the board's interpretation of their governing documents was overly broad and unenforceable. Patricia's response came 10 days later. It was dismissive and condescending, stating that the board had consulted with their own attorney and stood by their decision. She reiterated the 30-day deadline and reminded me that fines would begin accruing after that. "Well, I can't say I'm surprised," Margaret said when I forwarded her Patricia's response. "Some HOA boards see any challenge to their authority as a personal affront. Patricia seems like the type who needs to be in control. Let's file the lawsuit." We filed in Maricopa County Superior Court in early May. The complaint was straightforward. We argued that the HOA's restrictions on my business violated Arizona state law and that their interpretation of the governing documents was unreasonably broad. We asked the court to issue an injunction preventing them from enforcing the restrictions and to permanently dissolve those restrictions. The HOA responded with their own attorney, a lawyer named Richard Berkowitz from a firm that specialized in representing homeowner associations. Their answer to our complaint was aggressive, arguing that the HOA had broad authority to interpret and enforce their own governing documents, and that my business operations clearly violated the spirit and intent of those documents. What happened next escalated the situation from annoying to genuinely hostile. Patricia began documenting everything. She drove by my house multiple times a day, taking photos of my vans. She questioned my neighbors, asking them if they had noticed increased traffic or noise from my property. When none of them reported problems, she started finding other violations to cite me for. In June, I received a violation notice for having my trash cans visible from the street for more than 12 hours after collection. The next week, it was for a small brown spot in my lawn due to a sprinkler malfunction. The week after that, she claimed my house needed repainting, even though I had painted it just 2 years earlier and it was in excellent condition. Each violation came with its own fine and its own certified letter. It was harassment, plain and simple, and Margaret documented all of it. "This is actually helping our case," she told me during one of our strategy meetings. "It shows a pattern of targeted harassment. The judge will not look kindly on this." But knowing it helped our case didn't make living through it any easier. The stress was affecting every aspect of my life. I was sleeping poorly, constantly worried about what Patricia would come up with next. My girlfriend, Amanda, tried to be supportive, but even she was getting worn down by the constant drama. "Maybe you should just move," she suggested one evening as we sat on my back patio. "Find a house that's not in an HOA." "I shouldn't have to move," I said. "I'm not doing anything wrong. And I'm not going to let Patricia Thornton push me out of my home because she's on some kind of power trip." Amanda sighed. "I know, but is it worth all this stress?" I thought about that question a lot over the following weeks. Was it worth it? Part of me wanted to just give in, to pack up and find somewhere else to live. But the larger part of me was stubborn and angry. I had worked too hard to build my business and my life to let an overzealous HOA president destroy it. Our court date was set for September. In the meantime, the discovery process began. Margaret subpoenaed HOA records, meeting minutes, and correspondence. What we found was illuminating and infuriating in equal measure. The HOA board had never consulted their attorney before sending me that first violation notice. Patricia had made the decision unilaterally and convinced the other board members to go along with it. The meeting minutes showed that Linda and Carol had initially questioned whether they had the authority to ban my business, but Patricia had insisted they did. More damning was an email exchange Margaret uncovered between Patricia and another resident, a woman named Susan Drake, who lived 3 houses down from me. In the emails, Susan had complained that my vans were lowering property values, though she provided no evidence for this claim. Patricia had responded promising to take care of the problem and had begun her crusade against my business the very next day. This shows bias and improper motivation, Margaret explained. Patricia wasn't enforcing the covenants in good faith. She was responding to a personal complaint from a friend and using her position to target you specifically. We also discovered that several other residents operated home-based businesses that the HOA had never taken action against. A woman on Willow Court ran a successful online boutique and regularly had delivery trucks dropping off inventory at her house. A man on Desert View Drive operated a consulting business and frequently had clients visiting his home office. Patricia had never sent violation notices to any of them. Selective enforcement, Margaret said with satisfaction. Another nail in their coffin. As summer progressed and our court date approached, something unexpected happened. Other residents started reaching out to me. Some offered words of support. Others shared their own stories of dealing with Patricia's authoritarian approach to running the HOA. A man named Robert Carmichael, who lived on the next street over, stopped me one evening when I was checking my mail. "I just want you to know that not everyone agrees with what Patricia is doing," he said. "A lot of us think she's way out of line. The problem is, most people are afraid to speak up because they don't want to become her next target. Why doesn't someone run against her in the next election?" I asked. Robert laughed bitterly. "People have tried. Patricia has a core group of supporters and they all vote as a block. Plus, most homeowners don't even bother voting in HOA elections. They just throw away the ballots, so Patricia and her friends always win." This gave me an idea. After Robert left, I went inside and started drafting a letter to every homeowner in Meadowbrook Estates. In it, I explained my situation, what the HOA was doing, and how it could affect anyone who worked from home in any capacity. I pointed out the selective enforcement and the harassment I had been experiencing. I ended by encouraging everyone to pay attention to HOA business and to vote in the next election. I printed 300 copies and spent an entire Saturday walking the neighborhood, putting them in mailboxes. It was therapeutic in a way, taking some kind of action rather than just sitting back and waiting for the legal process to unfold. Patricia's response was swift and predictable. She sent out her own letter, claiming that I was spreading misinformation and that the board was simply enforcing the community's governing documents to protect property values. She accused me of trying to undermine the HOA and create division in the neighborhood, but her letter seemed to backfire. More residents reached out to express their support. Some even offered to testify on my behalf if needed. A petition started circulating, signed by over 100 residents, stating that my business operations did not negatively impact the community and that the HOA should rescind the restrictions. Margaret was thrilled. Public opinion won't directly affect the legal outcome, but it certainly doesn't hurt. And if some of these residents are willing to testify, that could be very helpful. As September arrived, I was a bundle of nerves. Everything was riding on this court hearing. If we lost, I would have to either shut down my business or move, both of which would be financially devastating. If we won, I could finally put this nightmare behind me and get back to living my life. The hearing was scheduled for a Tuesday morning at the Maricopa County Courthouse in downtown Phoenix. Margaret and I arrived early, going over our arguments one final time. Patricia showed up with Richard Berkowitz, her attorney, along with Linda and Carol. Patricia looked confident, almost smug. She clearly believed she was going to win. The judge was Harold Martinez, a man in his early 60s with a reputation for no-nonsense rulings. He had reviewed our briefs and the evidence we had submitted ahead of time. After we were all seated, he got right to business. This case involves a dispute between Mr. Quincy Stevenson and the Meadowbrook Estates Homeowners Association regarding restrictions on Mr. Stevenson's home-based business, Judge Martinez began. I've reviewed the pleadings and evidence submitted by both parties. I'd like to hear oral arguments, starting with the plaintiff. Margaret stood and approached the podium. She was calm and professional as she laid out our case. She explained the nature of my business, emphasizing that it was entirely office-based with no customer traffic to my home. She cited the Arizona statutes protecting home-based businesses and argued that the HOA's restrictions were overly broad and violated state law. Your Honor, Mr. Stevenson is not running a retail establishment or a manufacturing facility, Margaret said. He is doing administrative work from a home office, exactly the same as millions of Americans do every day. The HOA is attempting to ban an activity that state law explicitly protects. When it was Richard Berkowitz's turn, he argued that HOAs had the right and responsibility to enforce their governing documents to maintain community standards. He claimed that my business, by virtue of having commercial vehicles and conducting business activities from my home, violated the intent of the restrictions, even if it didn't violate the letter of them. The HOA's governing documents give the board broad discretion to interpret and enforce the covenants, Berkowitz argued. Mrs. Thornton and the board members acted within that discretion to protect the residential character of Meadowbrook Estates. Judge Martinez asked several pointed questions. Counselor, are there other residents in Meadowbrook Estates who operate home-based businesses? Berkowitz hesitated. There may be some residents who work from home, Your Honor. Has the HOA taken action against any of them? Not to my knowledge, but each situation is evaluated on its own merits. What specifically about Mr. Stevenson's business operations differs from someone who, say, runs an online business from home or does consulting work? Berkowitz struggled to answer that question in a way that made sense. He kept coming back to the commercial vehicles, but Judge Martinez pressed him on why vehicles parked in a resident's own driveway would constitute a violation when there was no specific prohibition against commercial vehicles in the governing documents. After hearing from both sides, Judge Martinez called for a recess to review the evidence again. We waited in the hallway for what felt like hours, but was actually only about 45 minutes. The tension was unbearable. Margaret tried to make small talk to distract me, but my mind was racing with worst-case scenarios. When we were called back into the courtroom, Judge Martinez looked at both parties seriously. I've carefully reviewed all the evidence and arguments presented today, as well as the documents submitted previously. This case raises important questions about the balance between HOA authority and individual property rights. He paused, and my heart was pounding so hard I could hear it in my ears. Arizona law provides clear protections for home-based businesses, Judge Martinez continued. Those protections are not unlimited. An HOA may enforce reasonable restrictions that address legitimate concerns such as noise, traffic, or aesthetic issues. However, the restrictions must be reasonable and consistently applied. He looked directly at Patricia and her attorney. In this case, the evidence shows that Mr. Stevenson's business operations create no noise, no unusual traffic, and require no modifications to his property. The only visible evidence of his business is 2 vehicles parked in his driveway. The HOA's governing documents do not specifically prohibit commercial vehicles, nor do they prohibit all home-based businesses. The board's interpretation is therefore overly broad. My chest loosened slightly. This was sounding good. Furthermore, the judge said, his tone growing more stern, the evidence shows selective enforcement. Other residents operate home-based businesses without any action from the HOA. This suggests that the restriction is being applied specifically to Mr. Stevenson, which is improper and suggests bias. Patricia's face was turning red. She whispered something urgently to Berkowitz, who shook his head and gestured for her to be quiet. Additionally, the evidence of subsequent violation notices issued to Mr. Stevenson for minor infractions that are not typically enforced suggests a pattern of harassment. This court does not look favorably on HOAs that use their authority to target individual residents. Judge Martinez shuffled his papers and then looked at me. Therefore, I am ruling in favor of the plaintiff, Mr. Quincy Stevenson. The HOA's restrictions on his business operations are declared invalid and unenforceable. The HOA is hereby permanently enjoined from enforcing any restrictions on Mr. Stevenson's home-based business operations as they currently exist. Relief flooded through me so powerfully that I felt lightheaded. Margaret squeezed my arm, her own face breaking into a broad smile. But Judge Martinez wasn't done. Furthermore, I am ordering the HOA to pay Mr. Stevenson's attorney fees and costs in this matter. The selective and improper enforcement of the covenants created unnecessary litigation that could have been avoided had the board acted reasonably and in accordance with state law. Patricia looked like she might explode. Her face was crimson, and she was gripping the edge of the table so hard her knuckles were white. Berkowitz was already gathering his papers, clearly eager to leave. Finally, Judge Martinez said, looking directly at Patricia, I want to make something clear to the HOA board. This ruling dissolves the restrictions on Mr. Stevenson permanently. Any future attempts to enforce similar restrictions against him or any other resident with similar home-based businesses will be viewed as contempt of this court's order. You understand? Yes, Your Honor, Berkowitz said quickly, before Patricia could say anything. Court is adjourned. Outside the courthouse, Margaret and I celebrated with a victory lunch at a nearby restaurant. I couldn't stop smiling. The nightmare was finally over. Not only could I continue my business, but the court had essentially told the HOA that their entire approach was wrong. The attorney fees ruling is crucial, Margaret explained over sandwiches. The HOA will have to pay us approximately $28,000 to cover my fees and the court costs. That's going to come out of their reserves, which means less money for community improvements. The homeowners are not going to be happy about that. Good, I said. Maybe it will make them pay more attention to who they elect to the board. Word of the ruling spread quickly through Meadowbrook Estates. By the time I got home that afternoon, I had over a dozen messages from neighbors congratulating me. Robert Carmichael stopped by in person with a bottle of wine. This is fantastic news, he said. Not just for you, but for all of us. Patricia needed to be knocked down a few pegs. The next HOA meeting, held 2 weeks later, was packed. Usually, these meetings attracted maybe 30 residents. This time, over 100 people showed up, filling the community center to capacity. I attended, curious to see how Patricia would handle the situation. She looked diminished somehow, her usual confidence replaced with visible tension. The meeting began with a financial report, which included the news that the HOA would have to pay $28,000 in legal fees due to the lawsuit. A murmur ran through the crowd. One resident, a man I didn't know, stood up. I want to know why the board spent our money on a lawsuit they had no chance of winning. Didn't anyone consult a lawyer before going after Mr. Stevenson? Patricia tried to deflect. The board believed we were enforcing the community's governing documents in good faith. But the judge said you were wrong, another resident called out. And now we all have to pay for it. The meeting devolved into chaos, with multiple residents demanding answers and criticizing the board's handling of the situation. Linda and Carol both looked miserable, clearly wishing they could be anywhere else. Patricia tried to maintain control, but she had lost the room. Finally, Robert Carmichael stood. I move that we hold a special election to recall the entire board and elect new members who will actually serve the community's interests rather than their own agendas. The motion was seconded immediately. Patricia tried to argue that the bylaws didn't allow for recall elections, but Robert had done his homework. He cited the specific section of the bylaws that did allow for recalls under certain circumstances, including financial mismanagement. The vote was overwhelmingly in favor. A recall election would be held in 60 days. Over the next 2 months, I watched with satisfaction as Patricia's grip on the HOA crumbled. A slate of new candidates emerged, including Robert Carmichael, who ran for president. They campaigned on transparency, reasonable enforcement of covenants, and respecting homeowner rights. Amanda, my girlfriend, was amazed by the whole saga. "I can't believe you actually won," she said one evening as we grilled dinner in my backyard. "I really thought they might wear you down." "So did I admitted. "There were times when I wanted to give up, but I'm glad I didn't. This is about more than just me. It's about standing up to people who abuse the little bit of power they have." The recall election had a record turnout for an HOA election. Over 70% of homeowners voted, and Patricia's entire board was removed. Robert Carmichael became the new president, along with a slate of board members who actually seemed interested in serving the community rather than controlling it. One of their first acts was to send a formal letter of apology to me for the harassment I had endured. They also implemented new policies requiring the board to consult with an attorney before taking enforcement action on complex or unusual matters. Patricia and Susan Drake, her friend who had started the whole mess, became increasingly isolated in the neighborhood. Most residents were furious about the wasted money and the hostile environment Patricia had created. I heard through the grapevine that Patricia was considering moving, though I never confirmed if she actually did. As for me, life returned to normal. Stellar Climate Solutions continued to grow and thrive. I hired 2 additional technicians that year and expanded my service area into Chandler and Mesa. My vans remained parked in my driveway, a visible reminder of my victory every time I came home. The legal battle had been exhausting and expensive, even though the HOA had ultimately paid my attorney fees. But it taught me valuable lessons about standing up for yourself, about the importance of knowing your rights, and about not backing down when someone tries to bully you. Margaret Chen and I stayed in touch. She sent me occasional updates about other HOA cases she was working on, many of them involving similar issues of overreach and selective enforcement. It seemed that Patricia Thornton was far from unique. HOAs across Arizona and the country frequently overstepped their authority, and homeowners often gave in rather than fight because the process was so daunting and expensive. About 6 months after the court ruling, I got an unexpected call from a reporter at the Arizona Republic. She had heard about my case and wanted to do a story about HOA overreach and homeowner rights. I agreed to be interviewed, hoping that sharing my experience might help other people in similar situations. The article ran on a Sunday in the local section, with the headline "Gilbert Man's Legal Victory Highlights HOA Power Struggles." It detailed my battle with Meadowbrook Estates, the court's ruling, and included commentary from legal experts about homeowner rights and HOA authority. The reporter had even managed to get a brief, defensive quote from Patricia, who insisted she had only been trying to maintain community standards. The article generated a lot of response. I received emails from homeowners across the state dealing with their own HOA disputes. Some were fighting over issues similar to mine. Others were dealing with everything from restrictions on solar panels to bans on certain types of landscaping. I tried to respond to as many as I could, usually referring them to Margaret Chen or other attorneys who specialized in HOA law. One particularly memorable email came from a woman in Temp who was being fined because her teenage son had painted a small pride flag on a rock in their front yard. The HOA claimed it violated their restrictions on yard decorations. I put her in touch with Margaret, who took on the case. They won, and the court not only invalidated the fine, but also ruled that the HOA's restriction on expressive displays violated First Amendment protections. It felt good to help others who were going through what I had experienced. The sense of powerlessness and frustration that comes with being targeted by your HOA is something that's hard to explain to someone who hasn't lived through it. Your home is supposed to be your sanctuary, but when an HOA decides to make your life difficult, that sanctuary feels threatened. The new HOA board under Robert's leadership was dramatically different from Patricia's regime. They focused on actual community improvements rather than finding violations. They repaired playground equipment that had been in disrepair for years, negotiated a better contract for landscaping services, and organized community events that brought neighbors together. At one of these events, a summer barbecue at the community pool, Robert pulled me aside. "You know, your lawsuit was probably the best thing that could have happened to this neighborhood," he said. "It woke people up. They realized that they needed to pay attention to HOA business instead of just ignoring it and hoping for the best." "I'm just glad it's over," I said. "And that something good came out of it. Are you going to stay in the neighborhood long term?" he asked. "I know you looked at houses outside of HOAs during all this." I had looked at other houses during the darkest days of the legal battle. Amanda and I had toured several properties in areas without HOAs, discussing whether a fresh start might be worth it. But ultimately, I had decided to stay. This was my home. I had friends here, a life here. And now, with a reasonable board in place, there was no reason to leave. "I'm staying," I told Robert. "This is home." Business continued to flourish. By the end of that year, Stellar Climate Solutions had grown large enough that I needed to rent a small warehouse space for inventory and equipment storage. Ironically, having that separate space meant even less business activity at my house. The vans came home at night and left in the morning, and that was it. Amanda and I got engaged that December. We had been together for 4 years, and she had stuck with me through the worst of the HOA nightmare. I proposed on Christmas Eve in front of the fireplace in my living room. She said yes immediately, tears streaming down her face. "I was starting to wonder if you were ever going to ask," she said, laughing through the tears. "I wanted to wait until all the legal drama was behind us," I admitted. It didn't seem right to start planning a future together when everything felt so uncertain. We set a wedding date for the following October and started making plans. Amanda moved in with me, bringing her belongings from her apartment in Scottsdale. The house felt more complete with her there, more like a real home rather than just the place I slept between work obligations and legal meetings. Life settled into a comfortable rhythm. I ran my business, which continued to grow steadily. Amanda worked as a nurse at Banner Desert Medical Center, and we fell into the easy patterns of domestic life. We cooked dinner together most nights, watched TV on the couch, took weekend trips to Sedona or Flagstaff. The HOA remained functional and reasonable under Robert's leadership. They enforced rules when necessary, but did so fairly and consistently. When a new resident wanted to install a home charging station for their electric vehicle, the board worked with them to find a solution that met everyone's needs rather than just saying no. When another resident started a dog walking business, the board reviewed it, determined it didn't create any issues for the neighborhood, and approved it without drama. It was amazing how much better the community felt with competent, reasonable people running the HOA. Property values actually increased, not because of strict enforcement of petty rules, but because people wanted to live in a neighborhood where they felt respected and supported rather than monitored and harassed. Patricia did eventually move, I learned from a neighbor. She sold her house and relocated to Surprise, a suburb on the west side of Phoenix. I never knew if she joined another HOA board there, but I hoped she had learned something from the experience. Probably not, but I could hope. Susan Drake, the neighbor whose complaint had started everything, remained in the neighborhood but kept to herself. The few times I saw her at community events, she avoided eye contact and stayed on the opposite side of whatever space we were in. I didn't bear her any particular ill will. She had been frustrated about something, probably something completely unrelated to my vans, and had lashed out. Patricia had weaponized that frustration for her own purposes. Susan had been a tool, not the real problem. My wedding to Amanda in October was a beautiful affair, held at a vineyard in Sonwita, a small town in southern Arizona. Many of our Meadowbrook Estates neighbors attended, including Robert and his wife, and several of the people who had supported me during the HOA battle. Margaret Chen came too, and I made sure to give her a special shout-out during my toast at the reception. To Margaret, I said, raising my glass, who taught me that sometimes you have to stand up and fight, even when it seems easier to just give in. Thank you for having my back. The crowd applauded, and Margaret, usually so professional and composed, got a little teary-eyed. Amanda and I honeymooned in Hawaii. 2 weeks of complete disconnection from work and responsibilities. When we returned, tanned and relaxed, I felt like I was finally, truly putting the HOA nightmare behind me. It would always be a part of my story, but it no longer defined my daily existence. Stellar Climate Solutions reached a milestone the following spring when I hired my 5th technician. What had started as just me, working from my truck and my home office, had become a legitimate small business with employees, a warehouse, and a growing reputation in the East Valley. I had commercial clients now in addition to residential ones, servicing HVAC systems for small businesses and offices. None of it would have been possible if Patricia Thornton had succeeded in shutting me down. Every time I thought about that, I felt grateful for Margaret's expertise and for my own stubborn refusal to give up. It would have been so easy to just close down Stellar Climate Solutions and go work for someone else. But I would have regretted it for the rest of my life. The judge's ruling had dissolved the HOA's restrictions permanently, exactly as the court document stated. But more than that, it had established a precedent. Margaret told me that other attorneys in Arizona were citing my case in their own HOA disputes, using Judge Martinez's reasoning to argue against overreaching HOA restrictions. I had become, in a small way, a part of case law. That was a strange feeling, knowing that my personal struggle had become something bigger than just me. But it also felt right. If my experience could help other people stand up to unreasonable HOA boards, then all the stress and expense and sleepless nights had been worth it. Years passed. Amanda and I welcomed our first child, a daughter we named Emily, and then a son, David. The house in Meadowbrook Estates became filled with the chaos and joy of family life. My business vans in the driveway were eventually joined by a minivan for hauling kids to soccer practice and piano lessons. Robert Carmichael served 2 terms as HOA president before stepping down, satisfied that he had set the community on a better course. His successors maintained the culture of reasonable governance and respect for homeowner rights. Meadowbrook Estates became known as one of the better-managed HOA communities in Gilbert, a place where people actually wanted to live rather than a place they tolerated because they liked the house. I never forgot the lesson that Patricia Thornton inadvertently taught me, that sometimes the people who seek power are the ones least suited to have it, and that standing up to them, even when it's difficult and expensive and stressful, is necessary. Not just for yourself, but for everyone who might be targeted next. Stellar Climate Solutions eventually grew large enough that I hired a general manager to handle day-to-day operations. I remained the owner and still took on special projects, but I was able to step back from the constant grind of running every aspect of the business. This gave me more time with Amanda and the kids, more time to enjoy the life I had fought so hard to protect. On the 10-year anniversary of Judge Martinez's ruling, Margaret Chen invited me to speak at a continuing legal education seminar she was giving on HOA law. I talked about my experience from a homeowner's perspective, about the fear and frustration of being targeted by your HOA, and about the importance of not giving up. The thing about HOAs, I told the room full of attorneys, is that they operate in this weird space where they have real power over your life, but most people don't take them seriously until they're already in trouble. By the time you realize you need a lawyer, you're already behind the 8 ball. The best thing homeowners can do is pay attention from the beginning. Read their governing documents, go to meetings, and vote in elections. But when that doesn't work, when you get someone like Patricia Thornton who sees the HOA as her personal fiefdom, you need attorneys who understand the law and aren't afraid to fight. The attorneys asked good questions about my experience, what I wished I had known earlier, what advice I would give to homeowners in similar situations. I answered as honestly as I could, trying to give them insights that might help their future clients. After the seminar, several attorneys approached me to say thank you and to tell me about cases they had won using the precedent from my lawsuit. It was gratifying to know that my fight had made a real difference, that it had helped shift the balance of power between HOAs and homeowners, at least a little bit. Looking back now, I can see how the entire experience changed me. Before the HOA battle, I was someone who generally avoided conflict, who tried to get along with everyone and not make waves. The lawsuit forced me to become someone who would stand up and fight when necessary, someone who understood that sometimes conflict is unavoidable, and that backing down isn't always the right choice. That change in perspective affected other areas of my life too. I became more willing to advocate for myself in business negotiations, more confident in standing up for my employees when they were treated unfairly by clients, more likely to speak up when I saw something wrong happening in my community. Amanda noticed the change too. "You're more sure of yourself now," she observed one evening. "Not in a bad way, just more confident, like you know you can handle whatever comes your way." She was right. The HOA battle had been a crucible that tested me and ultimately made me stronger. I wouldn't want to go through it again, but I also wouldn't trade the lessons I learned and the person I became as a result. Meadowbrook Estates continued to thrive as a community. Property values remained stable and even increased over time. The neighborhood maintained its attractive appearance without the need for harassment or aggressive enforcement. It turned out that most people took care of their properties and followed reasonable rules without needing to be threatened with fines. The few enforcement actions the HOA did take under Robert and his successors were handled professionally and fairly. When a resident let their yard fall into serious disrepair due to personal issues, the board reached out to offer help rather than immediately issuing fines. When someone violated the parking rules by leaving an RV on the street for weeks, they were asked politely to move it before any official action was taken. Most disputes were resolved through conversation and compromise rather than threats and legal action. This common-sense approach saved the HOA money and created a much more pleasant living environment for everyone. The contrast with Patricia's approach couldn't have been more stark. I sometimes wondered what Patricia thought about all of this, whether she ever reflected on her behavior and recognized that she had been in the wrong. Probably not. People like Patricia rarely engage in that kind of self-reflection. In their minds, they're always the heroes of their own stories, protecting the community from chaos and disorder. They never see themselves as the bullies they actually are, but that was no longer my concern. My life moved forward, rich and full and free from the shadow of HOA harassment. I ran my business, raised my children, and enjoyed my home without constantly looking over my shoulder for violation notices. The commercial van still sat in my driveway every night, a visible reminder of my victory and my refusal to be pushed around. Sometimes new neighbors would ask about them, and I would tell them the story of my battle with the HOA. Their reactions were usually a mixture of shock and admiration. Shock that an HOA would go that far, and admiration that I had fought back and won. "I don't know if I could have done that," more than one neighbor told me. "The stress alone would have killed me." "You'd be surprised what you can do when you have to," I always replied. "When someone's trying to take away your livelihood, you find strength you didn't know you had." The permanent dissolution of the HOA's restrictions, as ordered by Judge Martinez, remained in effect. The court's ruling was binding not just on the current HOA board, but on all future boards as well. They couldn't try to bring back similar restrictions without risking contempt of court charges. It was the best possible outcome, a complete and permanent victory. As I approached my 20th year of running Stellar Climate Solutions, I found myself reflecting on how close I had come to losing everything. If I had given in to Patricia's demands, if I had shut down my business rather than fight, my entire life would be different now. I probably would have ended up working for someone else, trading my independence and entrepreneurial spirit for a steady paycheck and the safety of being an employee. There's nothing wrong with being an employee, but it wasn't who I was or who I wanted to be. Building Stellar Climate Solutions had been about more than just making money. It had been about creating something that was mine, about being my own boss and making my own decisions. Patricia Thornton had tried to take that away from me, and I had refused to let her. In the end, justice prevailed. The court ruled in my favor, permanently dissolving the restrictions that Patricia had tried to impose. The HOA paid my attorney fees, a financial consequence that forced them to reckon with the cost of their overreach. Patricia lost her position of power, voted out by neighbors who were tired of her authoritarian approach. The story could have ended differently. I could have lost in court, forced to shut down my business or move to a different home. The HOA could have won, emboldened to continue their harassment of anyone who didn't fit their narrow definition of acceptable behavior. But that's not what happened. What happened was that I stood up for myself, fought back against injustice, and won. And in winning, I made things a little bit better not just for myself but for everyone in my community and everyone in Arizona dealing with similar HOA overreach. That's the legacy of my battle with the Meadowbrook Estates Homeowners Association. Not just a personal victory, but a small strike against the kind of petty tyranny that HOAs too often represent. A reminder that homeowners have rights, that those rights are protected by law, and that standing up for those rights, even when it's hard, is worth it. My home remains my sanctuary. My business continues to thrive. My family is happy and healthy. And those commercial vans sit proudly in my driveway, exactly where they belong, a testament to the fact that I refused to be bullied and that, in the end, the law was on my side.